బ్రేకింగ్ న్యూస్ చూస్తున్నాం. బీసీ రిజర్వేషన్లకు సంబంధించి హైకోర్టులో వాదనలు ప్రారంభమయ్యాయి. అయితే బీసీలకు అనుకూలంగా తీర్పు వస్తుందా, ప్రభుత్వానికి అనుకూలంగా తీర్పు వస్తుందా లేదా అనే దాని మీద అయితే ఉత్కంఠ నెలకొంది. అందరి చూపులు ఇప్పుడు హైకోర్టు వాదనల వైపే ఉన్నాయి. అయితే బీసీలకు రిజర్వేషన్లకు సంబంధించి బిల్లు ఆమోదించారా అని న్యాయస్థానం అడిగిన ప్రశ్నకు అడ్వకేట్ జనరల్ సమాధానం ఇచ్చారు. అయితే గవర్నర్ దగ్గర పెండింగ్ లో ఉంది అని ఆయన సమాధానం ఇచ్చినట్లుగా తెలుస్తోంది. రిజర్వేషన్లు 50% మించితే ఎన్నికలు రద్దవుతాయనే నిబంధన ఉంది అని పిటిషనర్ల తరఫున న్యాయవాదులు వాదిస్తున్నారు. మొత్తానికైతే వాదనలు అయితే కొనసాగుతున్నాయి. ఇప్పుడు హైకోర్టులో జరుగుతున్న వాదనలు లైవ్ లో చూద్దాం.
The rest of the seats must be as for the general category. So today also we are not asking for the stay of the election process. We are only saying that let the elections be conducted in accordance with the law passed by the state legislature. Para 14, it was urged that population of OBC in some of the local bodies is more than 50%, and for that reason percentage indicated in the report submitted by the commission is a conservative approach and needs to be taken forward. That cannot be the basis to disregard the constitutional mandate and need to observe the triple test procedure indicated by this court. The political parties who claim to be the protagonist of participation of OBC in the governance of local bodies are free to nominate candidates belonging to the OBC category in the constituencies concerned, and even against all the general seats available for reservation of scheduled castes and scheduled tribes. We do not wish to dilate on this on any consideration. The operative portion Madhya Pradesh came in para 27, 189. Now, just to conclude on this, page 189, only two paragraphs. 189, the same, you cannot conduct elections unless para 27. Lots of you may just make a note of that. That para 27, they say that you can't hold elections unless you comply with the triple test. And what is important, because in para 31, they say the directions we have given is not just for Maharashtra and Madhya Pradesh. It's for all states and election commissions throughout India. So, this is critical, Not only we now have Krishnamurthy and Vikas Gawali, but a Supreme Court order giving a direction under Article 141 that you cannot hold elections if you do not comply with the triple test. Para 31, I'm sorry. And 31. We once again make it clear that if the delimitation is not done by the state government in terms of the Amendment Act, or the triple test is completed in all respects for providing reservation so and so, the state election shall give effect to this order in respect to so and so which have become due. We also make it clear in this order that directions given are not limited to Madhya Pradesh State Election Commission, State of Madhya Pradesh, Maharashtra State Election Commission, but to all states, union territories and the respective election commission to abide by the same without fail to uphold the constitution. So the direction now given, the all states it has been given, and I'll conclude by showing that the final interim order, page 171. Page 174. Maharashtra went ahead and notified the elections. The Supreme Court said that since you have not complied with the triple test, you cannot proceed further. 174. When the matter came up, this is the Lordship's query. This came from the High Court. On the issue of interim, the High Court, Bombay High Court refused to grant interim relief. Matter went up to the Supreme Court. When the on the issue of interim relief only. When the matter came up before this court on 6/12/2021, it was directed that the Maharashtra State Election Commission shall not proceed with the election program as already notified, providing reservations for as a triple test compliance required under decision of 3-judge bench in this court was not done. Not the Supreme Court intervened, and then the operative directions was given for again for all states and page 178. The last paragraph, we reiterate that similar dispensation be followed, including the compliance of triple test by all states or union territories if they intend to conduct election of local government and provide for reservation for the OBC category. In case the state or the union, this is to what direction? In case the state or the union territory is not in a position to fulfill the triple test requirement, and the election to any of its local bodies cannot be postponed beyond the statutory period, the concerned state election commission ought to notify the proportionate seats as open category seats and proceed with the election of the local bodies. On page 180, my lord.
These matters are pending for final.
But these are the interim orders. So, my lord, on page 180 also, they said any election program already notified also has to comply with the triple test. Just to conclude, Manu, my submissions are number one. My submission number one, that the legislative pedigree has not been satisfied. Two, the constitutional requirement of 285A has not, sorry, the statutory requirement of 285A has not been satisfied. Three, the triple test in Krishnamurthy and Gawali has not been satisfied. And four, para 13, it must be local body specific and it cannot be done. There's a final contention, my lord, which our own High Court has said. You anyway cannot do any reservation on the basis of unpublished data. That my friend will show. But this is my focus. I'm grateful for your patience.
Yes. Yes, I'm appearing in item number 24 and 42, my lords. Lordship may kindly see.
You can give a small sheet, right? All these four propositions. Not in detail, because
no,
detail.
One page, one page.
That's similar to what my friend argued, but a little more dilation, my lords. Kindly see, my lords, my argument primarily is, my lords, there are actually two laws. The learned AG on 27th argued on legislative competence, and I seek to take issue with that. My lords, when there are two laws, the law declared by the Supreme Court is law, and I would say stands on a higher pedestal than statutory law. So, my lords, there are two laws. One is the law declared by the Constitution Bench of the Honorable Supreme Court in Krishnamurthy with regard to local body election. But, my lord, they have taken inspiration from Indra Swani and have held, my lords, 15.4, 16.4. The benchmarks on which you identify persons for 15.4, 16.4 may be different, as opposed to political representation in local body election, how you identify BCs and all. Those may be different. But, and this is only relevant for your lordship, my lord, insofar as the cap of 50% is concerned, the cap of 50% will apply to 15.4, 16.4 as also the local body election articles.
This is what he has argued.
Yes. So therefore my contention, my lords, is the law says, the law as held by the Honorable Supreme Court under 142 says, under no circumstances for backward classes, you shall breach the cap of 50%. The only exception in Rakesh Kumar, my lords, which was made was that insofar as scheduled tribes are concerned, in scheduled areas,
that was
you
from
can
Jharkhand.
And one more point which the Honorable Supreme Court said was, taking direct inspiration, my lords, in item number 42, there's a compilation. My lords may kindly see, it's a yellow compilation. Just for ensuring that the page numbers match, my lords, there is an important point here, my lords, which towards the end of the argument, the state had stated before the court, that there are certain exceptional circumstances in which 50% can be breached. The court has said that it is only with reference to far-flung areas which are cut off from the normal rule of life or the normal stream of life, will you apply? Uh, can you breach 50% cap? Manoj? Please see. I'll just take your lordships to that relevant portion. There's an important point here, Malaj, because the state may argue that insofar as the state of Telangana is concerned, that extraordinary situation applies. That has been clarified later on. But please see, in my compilation, page 24, para 65, while dealing with the contention of senior advocate Rajiv Dhawan, please see the insert paragraphs of Indra Swani, Malaj, para 65.
This is of which case? Which judgment?
This is with regard to the first case of your lordship compilation, Krishnamurthy.
Krishnamurthy.
Yes, madam. That's the crucible on which all other judgments.
This was also pointed.
Yes, madam. But this particular point I wanted to stress on, which my learned friend skipped to the next part of Rakesh Kumar. Please see para 65, the inset part of 65. Please see this. From the above discussion, my lords are there, Malad.
Yes.
This is directly applying the principle in Indra Swani. From the above discussion, the irresistible conclusion is that follows is the reservations contemplated in clause 4 of Article 16 should not exceed 50%. Now, while 50% shall be the rule, it is necessary not to put out of consideration certain extraordinary situations inherent in the great diversity of this country and the people. It might happen that in far-flung and remote areas, the population, lordship may stress on those words, madam, population inhabiting those areas might, on account of their being out of the mainstream of national life and in view of conditions peculiar to and characteristical to them, need to be treated in a different way. Some relaxation in the strict rule may become imperative. In doing so, extreme caution is to be exercised and a special case made out. Now, my friend read out the fact that this exception has been applied to northeastern states, far-flung areas where almost 100% are reservations in excess of 50% do exist in some exceptional cases when it comes to the domain of political representation. For instance, legislative assemblies of the state of Arunachal Pradesh, Nagaland, Meghalaya, Mizoram, Sikkim. Recent decision as in Union of India, this court explained that why it may be necessary to provide reservations in favor of scheduled tribes that exceed 50% of the seats in panchayat located in scheduled areas. Therefore, the exception has been made only for scheduled castes and scheduled tribes. But in so far as backward classes are concerned, however, such exceptional considerations cannot be invoked when we are examining the quantum of reservation in favor of backward classes for the purpose of local bodies located in general areas. So we are talking of general areas, my lords. Your lordships had asked a question whether we are talking of a district. It is not a district. It is general area, the entire state of Telangana which we are discussing, my lord. On this point, I would make a respectful submission with the greatest respect to this honorable bench. This honorable bench is bound by a by a full bench order of this honorable court way back in 87, when the state wanted to increase the reservation to 44%. In your lordship's compilation, please see this decision, my lord. Your lordships, my lords, with greatest respect, my lord, the court, this honorable court is bound by that decision. I'll only take your lordships to the operative portion of this lordship's decision, just Jeevan Reddy's decision, my lord. Please see page 568. The decision begins, my lords, at 553. 553. It has become final. They struck down the reservation for BCs, which was made to 44%. Now, my lords, it was with regard to 15.4 and 16.4. Please see, I'm sorry, my lords, for the bulkness of this compilation. Page 568. The decision begins. Yes, my lord. V. Narayan Rao and another versus the state of it. Yes, please give a copy. Please see that copy. Now the decision begins. My lords, please see at page 553. Yes. Please see, whereas the operative portion, which your lordship will see at 568 for a moment. This is a 3-judge bench. It has become final. 44% reservation has been introduced, and the court strikes down that 44% reservation. Now, my lords, before your lordships read this, recently in 2018, the state sought to increase the reservation to 34%. That by interim relief, the court stayed it, applying the principle of Krishnamurti. This was even before 285 Cap A came on the statute book. But please see page 568. Now, this is before, my lords, the jurisprudence of Indra Swani came about. My lords, incidentally, the same learned judge gave that decision. But yes, my lord. Yes, 123, page 568. In fact, this decision has been referred to in Indra Swani also and referred to in Maratha Reservation, but please see this one. The above discussion yields the following broad propositions. The rule enunciated in Balaji and affirmed in Devdasan is that reservation of seats posts cannot exceed 50%. Now, this is before jurisprudence of Indra Swani comes about, based upon the Honorable Supreme Court Constitution Bench decision in Balaji. Maybe it is a ceiling, maybe it is only a rule of caution, but it has got to be adhered to. Lordship may stress this. Later on, the carry forward rule has been discussed. The Lords may not see that kindly, but please see para 124. In the light of the above principles, we must hold that the raising of the quota of reservation for backward classes to 44%, which together with unquestioned reservation, please notice this word 44, it's now 42, but it was done 44 then, which together with unquestioned reservation in favor of scheduled castes and scheduled tribes comes to 65%. Now it is 67, 2% more, then it was 65%. Is far in excess of the permissible level of reservation and must accordingly be held to be bad. The state may argue, my lord, this decision is with regard to 15.4 and 16.4. We hasten to submit that in Krishnamurti they said the cap of 50% as applied in 15.4, 16.4 by Indra Swani applies on all forced to local reservation. So the principle which has been laid down in this decision applies completely to this. And please notice that the operative portion of the order, my lord, in view, now please notice page 570, clause 6, my lord. In view of the decisions of the Supreme Court, my lords are there, I'm just reading point 6, my lord. Page 570. In view of the decisions of the Supreme Court referred to in our judgment, the total reservations under 15.4, 16.4, as the case may be, cannot as a general rule. The court had to say general rule because the rule had not yet been solidified, which it happens later on in Indra Swani 9-judge bench and so on. So they are saying as a general rule, exceed 50%, subject to marginal adjustment if the exigency so require. Situation may, however, be different whether carry forward rule is applied. The exigencies, your lordships have seen, the Honorable Supreme Court explain that far-flung principle. Therefore, my lords, they strike down at page 572, clause 13, 14, 15 of GOMS 166. My lords, please see para 126, clause 13, 14, 15 and 18 of GMS 166 dated 15/7/86 are struck down as violative of 15 and 16 of the Constitution. So the GOMS, which provides for 44% reservation, which takes the reservation to 65%, are struck down by this court. So I put a simple question to myself: if the full bench of this honorable court has held that the 65% reservation is bad because it violates 50% reservation, well, the question before this honorable court is: this court may, with great respect, be bound by this decision. There's another three-judge bench decision, my lords, of the Honorable High Court, my lords, wherein the second part of my learned friend's enunciation of that three-test principle, my lords, the triple test. You must have a commission. The commission must conduct a study, an empirical study. How that study is to be conducted was envisaged in this, and again a three-judge bench decision, my lord. Please see this judgment given by the same learned judge, my lord. Please see page 458 and 459.
Need not multiply the authority.
Yes, but I'm only trying to submit, my lord, that when a report is there and they're relying on the report in the GO, the report has to be published, objections have to be invited, and there has to be a process of that. If you don't do that, the report is bad in law is our submission. So my learned friend was referring to 1 and 3, 50% and the appointment of the commission. I'm referring to the manner of the manner in which the commission conducted its exercise. I'll just read this one point, my lord, if you're not able to see page 458. If, however, this is again a three-judge bench. Please see 458. The same learned judge, my lord. Page 458. It's the opinion is by two learned judges, my lord. I'm only reading one learned judge's opinion. They are all concurring opinions. Page 458. 458, para 25, the last sentence, if however, my lords are there, my lord, from the bottom, if however, page 458.
Yes,
Yes, para 35, yes. If however, from the bottom, my lords, please notice this. If however, this survey is sought to be made the basis for any other election, hereinafter, it shall not be so used unless it is published first, objections invited, considered, and after necessary inquiry. We are all innocent of this report. The state, my lords, refers to the report as the basis of the GO and says an empirical study was done by one-man commission. Where is this report? Have objections been invited? Has it been published? Completely silent.
Yes.
And please notice this, my lord. I should also not be understood in either affirming the truth of the said figures or the validity of the said survey. So in effect, what the court is saying, my lords, is that we shall not rely on a survey which has been done behind the back of the people.
Understood.
My lord, this is what, so my lord, there are both are three-judge bench opinions, my lord. Both with greatest respect are binding on this honorable court. And if your lordship were to see, now this is the law on the point. I just want to emphasize one point, my lords. My learned complete respondents, my lord, are saying, my lord, that the interests of backward classes are not being protected if this is not done. The chairman of the Constituent Assembly, my lords, Dr. Ambedkar, in Maratha reservation case, himself has said, and the basis for this 50% rule is not an invention of the court, but my lord, the basis of that, the germ of it was in the Constituent Assembly. I'll just refer to that one paragraph of Dr. Ambedkar, my lord, wherein he said to maintain a parity between formal equality in 15.1 and substantive equality in 15.4. A minority of the seats must only be reserved. You can't have it as a majority. He said if you reserve it for the majority, you will be denuding 15.1 and 16.1 of its content. And that will be violative of the Constitution. I'll just refer to that one paragraph because, my lords, what I was curious to know, is this an invention of the court? Is this a jurisprudence of the court? Or has its germs already been laid in the Constituent Assembly? Lordship may only see this one paragraph, my lords. page 329 of the Maratha reservation case by Honorable Justice Ashok Bhushan Malaj. It's a final order. It has some review apparently has been filed. They examined in great detail when when the petitioners argued, the state of Maharashtra argued that this 50% rule is a yardstick of the court. It needs to be reviewed. Please see page 329, para 391. Yes, madam. Dr. Ambedkar referred to Article 10(1) as a generic principle. Dr. Ambedkar observed that if the reservation is to be consistent on clause 1 of Article 10, well, these later came to be Article 15, it must confine to the reservation of minority of seats. And the Lordships quote the Constituent Assembly debate of that learned scholar, Malaj. Please see. The following is the part of the speech of Dr. Ambedkar in the Constituent Assembly. Now this is the actual speech. If honorable members will bear these facts in mind, the three principles we have to reconcile, they will see that no better formula could be produced than the one that is embodied in clause 3 of Article 10 of the Constitution. They will find that the view of those who believe and hold that there shall be equality of opportunities has been embodied in clause 1 of Article 10. It is a generic principle. At the same time, as I said, we had to reconcile this formula with the demand made by certain communities that the administration, which has now for historical reasons been controlled by one community or a few community, that situation should disappear, and the others also must have an opportunity of getting into public services. So he's looking at both the competing claims. One claim which says that reservation should be there, and the other one which says that reservation should not be there. Please see how he reconciles these conflicting views, Mala. Supposing, for instance, we are to consider. Yes, I'll just finish, Mala.
We saw that.
Yeah, I'll just finish, Mala. If my lords will so bear with me. Supposing, for instance, we are to concede in full the demand of those communities who have not been so far employed in public services to the fullest extent, what would really happen is we shall be completely destroying the first proposition upon which we are all agreed, namely that there shall be equality of opportunity. So if you give reservation in the manner in which the state is proposing to do now, 67% is vertical, Malaj. You also have horizontal reservation which will cut through vertical reservation for women. So you have reservation for women which will cut through the general reservation and also will cut through the vertical reservation. This will be almost completely giving reservations, and which Malaj, the chairman, is envisaging should not be done because it violates equality of opportunity under 16(1). Let me give an illustration. Supposing, for instance, reservation were made for a community or a collection of community, the total of which came to something like 70%. We are now talking of 67%. Constituent Assembly in 47-48 is looking at 70% reservation. Please see what he says on this. Of the total posts under the state, and only 30% are retained to the unreserved. Could anybody say that reservation of 30% as open to general competition would be satisfactory from the point of view of giving effect to the first principle, namely that there shall be equality of opportunity? So he's looking at the condition. If you give 70% reservation and you only leave out 30% to the general part, will you be giving enough credence to equality of opportunity? And there's his answer now, Madam. It cannot be in my judgment. Therefore, the seats to be reserved, if the reservation is to be consistent with clause 1 of Article 10, must be confined to a minority of the seats. So this is the intention of the Constituent Assembly. My lords, always, when your lordships are interpreting constitutional or statutory provisions, are free to look at secondary modes of interpretation, one of which is the Constituent Assembly debates. Whereas if we go back and examine why your lordships put that benchmark of 50%, my submission is it is there in the Constituent Assembly debates. This,
Understood.
yes, my lord. I'll just summarize. My lord, therefore, my lord, my respectful submission is this is what the law says. Now, if your lordship were to come to the statute, just for a moment, I'll read the statute, and it is My respectful submission is the statute, it's not a substantive provision. All that the statute did in 2018 December was to give effect. The intention was to give effect to what the Honorable Supreme Court has been saying. So please notice this. Supreme Court is saying, in pursuance of the judgment, I can't think of a section which begins like this. In pursuance of the judgments of the honor, in fact, Justice Shavali said they should have referred to the judgments of the Supreme Court, then the section would have been complete. He said so in the arguments on 27th, but your lordships have now seen the decisions. In pursuance of the judgment of the Supreme Court of India, the upper ceiling of 50% vertical reservation should not be breached. And accordingly, this is the first part. The second part, the state has not complied with. Please see the second part also. Notwithstanding anything contained in 917 so and so and elsewhere in the Act, providing reservation for scheduled castes, scheduled tribes, the seats and offices to be reserved for backward classes shall be so determined, duly keeping, only one submission, duly keeping in view the requirement of reservation for SCs, STs therein. So what the section is saying is, no doubt you may make reservation for BCs, but while you're doing so, you must also keep the interests of SCs and STs in your mind. The state has not done that. Why they did not do that is, they have taken 2011 census of SCs and STs. Your lordship will see that in item number 24, my lords, or item number 42, in the Panchayat Raj Geo 41, which has also been challenged before your lordship, it is really eye-opening. Because what they're doing is violating the section, my lords. Please see. Page 32. The Panchayat Raj Geo, my lords, gives out the census for SCs, STs and BCs also. Please notice this table only for a moment, my lords. Page 32. So what the section is saying is, while you are making reservations for BCs, keep the interests of SCs, STs in mind. The Geo says there has been a proportionate increase of BCs. Therefore, we are reserving for BCs. The section says, no, you should keep the interests of SCs and STs also in mind. If that is so, what has the state done? Please see page 32 for a moment. At page 32,
Geo 41.
Page, Geo 41, my lords. In item 42, my lords are seeing.
Same.
Yes, my lord. Please see the second page of Geo 41, my lords. 41. The table, it's eye-opening because in so far as ST, SC population are concerned, they take the 2011 census. But in so far as BC populations are concerned, they are taking this the survey which has been done in 2024. Why? Well, if the section has to be given full effect to, which they are bound to do, shouldn't they have looked at the SC, ST population by undertaking the same examination for BCs, which they have taken up in 24? They should then come to a conclusion that the proportionate increase of SC, STs are not as much as BCs, and therefore we are making provision only for BCs. Argument's sake, if they do this exercise, they come to know that SC, ST population is very low. BC population has increased. They are not being properly represented in public life. We are giving effect to them. Have they done that? They have not done that. They have only looked at the population figures of BCs in 2024 as opposed to ST, STs in 2011. This violates the Act, my lords. And one more submission is that it violates the Act. The state was saying on the last occasion, on 27th, my lord, they said that Justice Pardiwala's opinion in State of Tamil Nadu decision has said if it is kept for the assent of the governor for a period of 1 month, it constitutes consent. I'll just put a question to myself. With great respect to the state, that is not what the Honorable Supreme Court has said in state judgment. Well, please take this copy. Well, this is important because on 31st of August, I'm sorry we are taking your lordships to this voluminous documents, but lordship will notice the State of Tamil Nadu versus Governor of Tamil Nadu. the direction insofar as the president is concerned has been given back by the president to the Supreme Court under advisory jurisdiction of can you do that. But please notice, para 220, 250.
Yes.
Yes. Please see page 2, para 250. At page 212, the bottom portion has the page numberings. What I'm only trying to say is that the GO has only recorded the fact that it is a bill. Unless it receives the governor's assent, it is not an amended situation. What the Supreme Court is saying, it's not like a deemed approval, my lords. Please see. Keeping in mind my lords are saying para 250. Keeping in mind the constitutional significance of Article 200 and the role it plays in the federal polity of the country, the following timelines are being prescribed. Failure to comply with these timelines would make the inaction of the governor subject to review, not deemed approval, subject to review by the courts. In case of either withholding of assent or reservation of the bill for the consideration of the president, upon the aid and advice of the State Council of Ministers, the governor is expected. Please notice that word. It's not a direction. It is an expectation. My lords, they have stretched 142 article to its limits. And 142 article has been, so they're very careful as to how they are referring to their equals in the executive side, which is the governor or the president. The governor is expected to take such an action forthwith subject to a maximum period of 1 month. He has to take action. Now see what happens. In case of withholding of assent, contrary to the advice of the State Council of Ministers, the governor must return the bill together with a message within a maximum period of 3 months. So he has to take action forthwith within a period of 1 month. If he disagrees, he must give back the bill within a period of 3 months. These timelines are important if we are to take this assumed consent or whatever. In case of reservation of bills for the consideration of the president, contrary to the advice of the State Council, the governor shall make such reservation within a maximum period of 3 months. So you should decide within 1 month. If you don't decide within 3 months, you must give it back to the Council of Ministers. And then, my lords, in case of presentation of bill after reconsideration, in accordance with the first proviso, the governor must grant assent. Now, please notice that word grant assent forthwith, subject to a maximum period of 1 month. But you can't read this sentence in isolation, independent of the earlier provisions, my lords, or earlier direction. So what it says is, you decide in 1 month. If you don't decide, give it back in the next 3 months. And if it comes back to you for after reconsideration of your council, if it comes back to you, then within 1 month, if you don't decide, then it is assumed assent. That exercise has not taken place at all. As my learned friend has submitted, on 31st of August, the legislature has passed a bill. They have kept it for the assent of the governor. We are still in the first August, September. 1 month has passed by. Now the second part of this provision, that within 3 months you must give it back to your Council of Ministers, that has come into effect now. After that is over, they give back the bill back to you. Then you must decide within a period of 1 month. If you don't, then there is assumed consent. But what the state appears to be arguing is, because in 1 month you didn't decide, therefore there is assumed consent. Well, that is also an argument in futility. Because the law declared by your lordships in the Honorable Supreme Court has held 50% cannot be breached.
All that.
Also, please also notice, my lords, just to conclude, my lords, in item 42, in item 202, item 42. My lords, in item 42, just one last submission, my lords, I'll just bet. In 2018, 34% reservation was introduced by the state. This came to be challenged before your lordships. In an interim order, your lordships stayed it. They
That
said
was shown. That
yes.
was shown.
That was not shown, my lords. Please see page 202. Only for a moment, please see page 202. I'll conclude, my lords, with great respect. I think I've gone into your lordship's lunch hour.
So great reservation is required for minor also.
Just see in item 42, just one paragraph I'll show. If your lordship were to see in item 40,
Please read it.
shall I read it? Yes, madam. This is in page 202. Is item number 42, my lords. Page 202. This is my lords, WP 25651 of 18. The fundamental issue, and this may be revelatory, my lords, when your lordships are considering whether to give or not to give interim relief. This interim order has been given 6 months before the enactment of 285 Cap A. It was given in the month of July. 285 Cap A came into the statute book in December of 18. The interim order is given in July of 18. So they're relying only on Supreme Court decisions without going into the thicket of section 285 Cap A. Now, please see the fundamental issue. That's why I wanted your lordships to kindly see it, my lord. The fundamental issue raised in this writ petition is regarding the reservation of seats in Gram Panchayats and other local bodies, which we hereinafter refer to as local self-government. The fundamental contention of the petitioner is that the reservation is in excess of 50%, which could not have been made in the light of the Constitution Bench decision. Only one decision the petitioner relies on, Krishnamurthy, and says 50% breach violates Krishnamurthy, please interfere. That's all he says. That's all the court also says now. Please see, in the light of Constitution Bench decision of the Apex Court in K. Krishnamurthy versus Union of India, the learned counsel for the petitioner, making reference to the said precedent, argued the position that it amounts to law by the Apex Court. Now please notice the operative portion, my lord, and this is revelatory. I'll just read that one paragraph and leave it, my lord. However, of the view that the law laid down by the Apex Court is clear and categorical to the effect that the upper ceiling of 50% vertical reservation in favor of SC, ST, OBCs should not be breached in the interest of scheduled tribes, should not be breached in the context of local self-government. Exception can only be made to safeguard the interest of scheduled tribes that your lordships have seen. In the matter of the representation in panchayats located in the scheduled areas, this is one of the specific enumeration conclusions rendered by the Constitution Bench after stating to the said effect in paragraph 64. So your lordships are referring to a paragraph and giving an interim order. This was before the act came into being. Paragraph 64 of page 227 of the judgment in K. Krishnamurthy, wherein the Apex Court had clearly taken the view that there cannot be any vertical reservation in excess of what has been noted above, that is over 50%. It has also to be noted that K. Krishnamurthy was decided making specific reference to the Constitution so-and-so amendment. Considering the submission of the learned GP on the basis of, this is the same thing they argued. The OBC population of the state has increased, we need to give them more reservation. My lords, OBC population, we are of the view that the only exception granted by the Apex Court through the directions in K. Krishnamurthy is only as regards STs and SCs. So the court is saying the only allowance which we can make to the state is with regard to SCs and STs when it goes above 50%, not to OBCs. Therefore, we do not find our way to accept the submission of the learned G. For the aforesaid reason, there shall be interim order that the upper ceiling limit of vertical reservation in favor of SC, STs and OBCs should not be breached in the context of local self-government in the state of Telangana, subject of course to the exception that safeguards could be made to protect the interests of scheduled tribes in the matter of representation in panchayat located in scheduled areas. So this interlocutory order is issued without prejudice. Against this order, the state goes in appeal to the Honorable Supreme Court, and then the SLP is withdrawn at page 205.
Very well.
So all I'm submitting, my lords, it's still the law of the land.
Hear the other side after lunch.
No,
I
wish
may I
to.
please, my lord? My lord, this is with reference to this matter, my lord, please me a moment.
We have heard this at the interim stage only. We'll hear the other side.
I wish to add for 10 minutes, 5 minutes, I'll take up. I'll be supporting
My
this.
lord,
And I'll not repeat what they have said.
Allow us to have the lunch.
I'm sorry. I'm sorry again.